criminal law attorney and former prosecutor. Jeremy Saland is with us now to talk more about the case. Good morning to you. Thanks for being here. What is the prosecution required to prove to get a guilty conviction in this case?
Well, they have to prove what I think they fairly easily laid out, setting aside any potential constitutional issues, for example, for vagueness of what it is to be an addict, but that he was knowingly, using or possessing those drugs, and he was addicted to drugs at the time he made the misrepresentation on that form when he purchased that firearm and then ultimately possessed that firearm. The law doesn't make there's no distinction between, for example, possessing that firearm for 1 day or 25 days or a year. It doesn't make a distinction if you filled out that form once or twice or 3 times, in the sense that once you've done it once, that's sufficient. So in substance, that's what they need to prove.
Then you've got the human element, Jeremy, here, and this is really leaning into sympathy that they may get from the jury, with several of them saying that they have family members who have struggled with addiction, and that is the mindset of Hunter Biden when he filled out that form, and whether or not he believed he was in the throes of an addiction at the time. How does that factor into the jury's deliberations, do you think?
I think in this case, it's a very real factor. And from what I've read, obviously I've not been in that courtroom and there's no cameras, but from what we've heard is that there was at least one juror who seemed to be upset and crying and tearing up, because we can all relate to addiction. We can all relate to someone either we know personally, could be a family member or a friend, or a story of someone who suffered and overcome that addiction, whether it's alcohol or drugs. And when you look at that dynamic, if you can play to just one person, although you want to play to the entire jury, maybe you can hang that jury and say one person will say, I'm not going to go forward on this, even if true. And then one other thing I would add, when you look at Donald Trump's trial and you look at Hunter Biden's future tax trial, no one gets emotional over falsifying business records or taxes. That doesn't hit home in sort of an emotional, really heart-driven sense. But when it comes to drugs and it comes to families, there is, as your reporter said in the field, a very visceral, strong, passionate response that could affect a trial.
And it's a high-profile case. The jury sees who's in the courtroom. They see the First Lady. How challenging is that for the prosecution to tell the jurors, ignore who you see, focus on the task at hand?
I don't think it's that hard, because the jurors should be, and you expect that they will, and that they know that the dynamic of this case and the magnitude of this case, that they're going to pay attention to the evidence, they're going to pay attention to the law. If there was distractions, for example, in a case where there's been a violent crime and a parent, yells out, that's very different. This here, there's observers, but I don't want to compare it directly, but we had Donald Trump's case. You had all those politicians who all wanted to get some airtime in that courtroom and outside of that courtroom. And, it doesn't help, but I think they ignore it, especially here. This is just family being family.
His daughter, Naomi, took the stand in his defense. Who do you think had the most compelling testimony on the stand, and how might it impact the jury's decision?
Well, I'm going to sort of work backwards and say I think it was a right move that Hunter did not testify, because he would have had the worst impact, unequivocally so, because there was so much impeachment material, meaning for cross-examination. His daughter could have been very helpful, and she was, but the prosecution did a good job of poking holes in her story. And really, when you look at it, it's a daughter who really wants to say, my father's getting better, but that's belied by really the text messages that don't really stand for the same thing that she's saying. But you heard from family members who the defense pointed out, some of them testified under an immunity agreement here, but you heard from family members who are really compelling witnesses. But none of them said during that 11-day period, or at that time of the signing, not that you have to be using drugs in that exact moment and addicted, 10 days before, 10 days later, but they did not really say, in those 11 days when he possessed that gun, that's their argument. None of them could point to it. But there was compelling evidence, residue, gun, text messages, and his own words. His own words were really, really damning.
I know it's tough to do, but any prediction on what you think the jury will decide here, Jeremy?
On the merits of the case, solely looking at the law and solely looking at the evidence, he's guilty. Though, again, I can't stress enough what that means to be addicted. And we've seen a Fifth Circuit decision that on a similar matter, saying, well, that's too vague. What does it mean to be addicted? You're an addict forever, even if you're sober. You're an AA. So there's a lot of interesting questions that would be grounds for an appeal. But I can see a jury convicting if they don't use those heartstrings and say, you know what, this doesn't belong here.
Yeah, there's some ambiguity around it. Jeremy Saland, thank you. Appreciate it.
My pleasure.